Stand for the pledge of allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, roll call if we may, please.
George Andrews,
Present.
Jason Goldstrand,
Present.
Debbie Kulik,
Present.
and Keith Carcott. Should be
He's
joining us
supposed to be
by
on Zoom.
Zoom.
He's supposed to be on Zoom, but I don't see him yet. Okay. I will look for a motion to adopt the agenda for August 19th, 2024, with members of the committee reserving the right to add to the agenda and take further action as the committee deems appropriate.
So moved. Second.
George, then Jason. Any other questions? All in favor?
Aye.
Okay. Now looking for a motion to approve the minutes for June 17th, 2024. And there was no meeting in July.
So moved. Second.
Jason and George, any other information? If not, all in favor?
Aye.
Okay. We have a significant list of updates, which are all from PSBA via their newsletter. And the first one is policy 218, which is student discipline.
Yeah, well, on the pin, on the newsletter. We got this in June. Can the committee get a copy of this pin when it comes in? We got it in June and we're now just seeing this for the first time. And we have all the things are changed based
Right,
on
this
this
came
pin.
out the day before
What?
the day before the last meeting it had come out. And I could give it to you ahead of time, but now you'll have access to it when you have board docs.
What?
You'll have access in board docs to all the.
It's gonna be in
and then
board doc?
Yeah,
as soon
going
as they
forward, you'll have
release.
immediate access when it comes up on PIN.
Oh, it will come in board doc, whether,
Yes,
I think I've gotten board docs to the point that I can log on and read some stuff. No, yeah, that'll work.
so going forward, you'll have
Yeah.
immediate access.
Yeah.
As soon as it's released to
Yeah,
us,
that's-
it's released on board docs.
Well, that's
Okay.
great, yeah.
There you go, George.
Another good
But
reason
I
to,
just wanted. Because if we had this last month. We're now, we had this in June, we could have had a lot of stuff taken care of by then.
We didn't, well,
well, but I would say though.
Doesn't make any difference.
Yeah,
Yeah.
but you know what,
It
George,
doesn't
you bring up a good point, because if it would make a difference. Then we would have to have this conversation. The issue is that. The recommendations by school boards. Are typically taken because what school boards will never do is. Take something that's been customized for the district and take it out of the policy, unless it's illegal.
Yeah.
Then they would, right? Then the recommendation would be there, so. I don't want to say that. These are just standard protocol, but they really are. And that's not to make you feel like it's a rubber stamp, because it's worth reviewing.
Yeah.
But again, unless it's something that's specific to the district. The changes that school boards recommends are legal changes with language that are going to either broaden the scope of your responsibility or narrow the scope of your responsibility based on the law.
Yeah, and
Make sense?
And it changes like from police department to law enforcement.
Exactly.
I mean,
Yep.
they're basically all grammar things.
Like in our case, for instance, our police, the school police, East Stroudsburg Area School District Police. Don't have the same authority with regard to arrest powers as the local police department. So therefore, what they're making sure of there is to make sure that we communicate. Some of these events that could happen with local police,
Yeah.
local law,
got it.
right?
But they don't call them local officers.
Well, they call them local law enforcement
They
agency.
changed it to the,
George, I'm gonna start with page 1,
okay, no problem.
okay?
Yeah. The only thing I say, I have to, I'm
So,
gonna miss the.
The first policy that we're going through is student discipline. And there was just a change from the board shall to the board may.
Right.
And then if we go to the third page, there's adding an or, giving an opportunity for an and or for protection of persons or property. And then adding tobacco products. And in taking out the Safe Schools Act and saying in the school safety and security provision of the school code with the references. where George was talking about saying the local police department, it just
Yeah,
says
that's
law
fine.
enforcement
Yeah.
agency.
Right.
Which also is changed in the next paragraph. And then taking out, in accordance with the state law. Referring instead of to the Office of Safe Schools, the PA Department of Education. And that would be the changes and the updates for that particular.
George, in case you're wondering, or anybody else is wondering why Office of State Schools been taken out, they've always been part of the PA Department of Education, but people always assume they were a separate group and they're not. So they're just saying, okay, we're the Department of Education, so therefore, I guess it would give you more, it doesn't give you any more or less authority, but it makes people understand, oh, this is
Well,
under the
this is
Department of
where it is,
Education.
right?
This is not a separate office.
Yep.
The full umbrella, correct?
Yes.
Okay. Next one is section 200 under pupils, the weapons policy. And the change happens on the third page of that, where once again, they take out the Office of Safe Schools and use the PA Department of Education on whatever required forms. They make the add the addition of in accordance with law.
That's right, yeah.
And then instead of the federal gun-free school zone, it just says federal law, which I would think is a little more global. Any question on any of that?
And it's less, people won't argue about that.
Right,
It's gun control.
okay.
Right.
Then we go to the next one, which is the update on same section 200 pupils, terroristic threats. And the change made to that is on page 2, where once again, it refers to the Office for Safe Schools and now talks about being under the PA Department of Education on the required form. Any question on that? All right, going to section 800 operations, and this one's titled Public Records. On the first page, there is a substitution of an or instead of an and, or a financial audit record or financial audit report. On the second page, it talks about the requester is a person that is a legal resident of the United States who requests access to a record. And then it says the term requester includes an agency. And then there's an added portion here under authority. The board authorizes the district to deny anonymous requests for records. A request may be considered anonymous if the requester has submitted insufficient information for the district to identify the requester, if the requester is a legal resident of the United States. Makes sense. And then on page 3, they take out in the sentence, the district shall post at administration office and on the website. If the district maintains a website, it just refers to a website. And it adds a bulleted point saying that the district shall post the acceptable forms on the district website with information notifying requesters that the district may choose to deny a request for failure to submit the proper form. And page 4, it talks about requests made in accordance with the policy may be submitted to the district in person by mail or to a designated email address and must include the following information. And added to the current information required, it is in sufficient detail to allow the district to determine what records are being requested. Under fees, it says, except this is an addition.
Is it insufficient? Well, it says it's okay, should be, that should be one word, right? Or the 2 words insufficient.
Which one?
This may be a spelling error on the number 1. Is insufficient one word?
In,
Is they have it as 2 words, at least that's what it looks like in mine.
I think it in, and then sufficient, it's 2 words.
Yeah.
It's
Is-
2 words, it's not insufficient. it's in sufficient detail.
Oh, okay.
Okay, got it?
You actually need probably the in out that makes it clear.
Yes.
But.
But they put it in to challenge you, George.
Huh?
It's in to challenge.
Sometimes, yeah.
Making sure you're reading it.
Okay, under fees, except, and this is addition, except for the duplication fee established by the state. It says the board shall approve a list of reasonable fees relative to requests for public records. Added is the district shall maintain a list of applicable fees and disseminate the list to requesters. And that's all that's changed on that page. There is an addition on page 5 at the top that is the initial response shall grant access to requested record, and added to that at the end is or request more detail from the requester to clarify, to clearly identify the requested material. So we're just adding things to make things more specific. Under granting of request, if the open records officer determines that it'll be granted, they shall inform the requester that access is granted and either include a copy of the requested records, which has been added to the list, information on regular business hours when they can be obtained, etc. And we added a comma at the bottom. I'm sure we all missed. And it also adds to the end of that, which is why we added the comma, that a public record that the district does not possess, but is possessed by a third party whom the district has contracted to perform a governmental function, which directly relates to that government function, comma, shall be considered a public record of the district, and this is added, and shall be made accessible in accordance with law, board policy and administrative regulations. And then down at the bottom, it says the open records officer may deny a request to for access to a record if the requester has made repeated identical, the word identical is added, requests for the same record. And then we've changed the appeals title. It's the state's Office of Open Records with 15 days of mailing date to the right to know, and I'm assuming that the right to know open records officer, the right to know should be there, or just open records officer? Would right to know be crossed out again?
You're talking in the,
Under appeals,
no, that's correct where that is.
so the date of the right to know open records officer's response. But they crossed out right to know up top, which is why I'm asking.
The first one is the state's
Office of Open
officers. will
Records,
open-
So, but here it's the right to know
It
open
is.
records officer.
right to know officer.
No, right to know comes out, it should be open records officer.
Yeah, switch this. You refer to it open records. These are different. This was an open records officer or.
So,
It gets, yeah, what the state has done nicely there, we have open records officer, which is here, the ORO, and then we have the Office of Open Records there, which is the OOR. They made it, they brought them together for us just to make it clear. So
as
you're
mud-
correct, we're switching
As
it.
mud, okay,
Clear as mud.
that's it.
That's okay.
And appeals involving third-party records, and we apparently use this term, the right to know officer shall provide notice to a third party within 7 business days of any appeal relating to records requested, which affect the legal or security and case of an employee, contain or constitute propriety, confidential or trademarked records of a third party, or are held by a third party contractor or vendor. The district shall notify such parties of the appeal and advise them of their ability to participate in accordance with law. The right to know officer shall also provide proof of such notice to the Office of Open Records within 7 business days of sending the third-party notification. And that gets us through that particular section.
Could I make a suggestion?
Go ahead.
Throughout this, I see your confusion now. When we read these terms, we're so used to them that we know what it means. But if you go all the way back to, I'm going to say it's page 2, under authority, where it defines, or I'm sorry, delegation of responsibility, it sets, I think, the proper term right there. The board shall designate an open records officer. So I'm just going to suggest we either switch that term to right to know officer, or we switch all the others, as long as they're consistent, if that makes sense editorially, so the
I
district
would-
position's the
I
same.
would agree that they should probably all say open records office.
That's the state's more common term, so I don't know why the PNN would volley, but we read right through it, so apologize for missing that. I probably read this one 3 times too. Didn't notice it was bouncing back and forth.
All right, well, now.
Well,
that
just Debbie, just to clarify, the open records officer is the same as the right to know officer, correct?
Yes. We can't see you, so I didn't know you were there,
Oh,
sorry.
I'm here. I'm on video. Oh, you can't see me. Okay, I'm here though.
Not on my screens here, you're on the screens out front.
Hi. All right, thank you.
Thank you, Keith. All right. We'll go to the next one, which is, again, section 800 operations. And this one is school calendar. It has a number of clarifications. And it talks about the annual school calendar. And it says, the efficient operation of the district. And added is, and communication with students, staff, parents, guardians, and the school community. Under authority, it adds, in accordance with state law and the words and regulations. And that, activities qualifying as instructional days and added is or hours under the direction of certified school employees. Says the minimum required days or hours are added of instruction under law, regulations, and state guidance is added. Under school calendar, it says it normally consists of 180 student days. And added is or 900 hours of instruction at the elementary level and 990 hours of instruction at the secondary level. And talks about the board having the right to alter the calendar when it serves the best interest of the district, including, and this is added, cases of emergency in accordance with applicable law and regulations. And then on the page 2 of this, it adds that everything is in accordance with law, that's added, and then keeping school sessions such days, and it's instead of number of days per week, it says hours as the board deems necessary, which shall include maintaining the requirement for a minimum of 180 student days or 900 hours of instruction at elementary and 990 of instruction at secondary. And then under delegation of responsibility, it includes the board policy. It says in regulations guidance from PA Department of Education and board policy, and is added there.
I just have a couple of questions about this policy in general. This isn't the new law that was enacted, correct? We, because it used to be.
About the hours,
Yeah, it used to be 180 or, no, it used to be 180 and 990 hours. So you had to accumulate, but now, from what I understand, isn't it? The 180 days or the 990
Yeah,
hours?
what they
So-
didn't want
so
to
they
do,
split it.
yeah, they didn't want to just give you the 180 now in case of emergency. So I think COVID is what brought that to light for everybody. And they needed an out. Because clearly we weren't gonna make 180 because there was at least 2 weeks where none of us could do anything because we were supposed to go back to work after or back to school after 2 weeks, right?
Right.
So they had to give us an out, otherwise they'd be breaking their own code. So then the hours was always there. They just didn't allow the flexibility to utilize hours. Like for instance, in Upper Marion, if we got caught up with snow days. And let's say I'd already extended the school year by 3 days. And going over down there is a very like down there, you don't touch spring break. It's sacred. You don't even ever discuss shortening spring break. So what would happen is we would just back off the hours. We had many more hours than 990 put in, and then nobody cared. And we
But as
didn't
long
do
as
that
you hit
before.
180.
So that's what it is. Yes, in some cases, well, if you look at it from a logical perspective, seniors never get to 180 for the most part.
No.
And you could even argue that underclassmen especially don't get to 180 because typically they're kind of out before, sometimes, in some cases, in some districts, before graduation even occurs. So that's why they had to do it, because it wasn't realistic.
So theoretically, and I'm not saying that this is gonna occur, but so theoretically, you can say, instead of moving snow days, like you have 3, because I know in East Stroudsburg, we take the snow days and then we take the, the instructional
Yep.
days. Theoretically, at the end of the year, those days don't have to be made up because you reach the 990 hours.
You could
Because
do
it's
that.
no
with
longer required the 180. I'm not saying we would do that.
You're gonna have to, snow days would not be a reason to count that unless you can justify it in some emergent purpose. That's the problem. So the other piece to look at is I want to see how.
Well, let's just say this, for example, because we have the hours, say during Keystones or Community Days, you decide to run a 2-hour delay schedule
Yep.
on those days.
Yep,
I mean, we accumulate over 1,300 hours in a year, so
Yeah.
you
could easily do that.
reach that. Okay,
Yep.
so it
Yeah.
gives us a wider flexibility.
It does,
Okay.
absolutely.
Yeah, and we do that now and historically have, because those days counted because we were here even under the old arrangement.
Right.
But this law, when it was enacted, was one of the reasons we were able to make the adjustments we did in our district even last year with the earlier graduations when underclassmen stayed, because we didn't impede or impact any of the instructional time. Ironically, that the part of the law that hasn't been tested yet is because it's hours or days, and they didn't define what a
Right.
day is in the law. Is that where you're headed?
Yeah. That's
Yeah,
what
yeah, in theory, right now, a district could probably hold 4-hour school days 180 times and be done and
Well,
not even make the hours.
Don't get kids excited.
But so
I
it's
understand.
Get to, you want to be very careful because the optics of just working by hours. And then what do? Then ultimately, you're going to wind up in a situation where there's going to be a group of people, i.e. taxpayers, are going to say, well, wait a minute, that's how you're going to work, and you better start taking hours back from all of the employees,
Right.
right? So it's a really slippery slope. So that's why it really has to, it's only used by us in an emergent situation or in a situation where you go, wait a minute, what are we doing? This is crazy not to just use the hours
Right.
to get everybody out of here, because as far as I'm concerned, I just think that we should, my personal belief is we should always start school before Labor Day and get out as early in June as possible, because learning is,
They don't want.
it's questionable. I mean, it's just, you're literally killing time, right? So.
Okay.
It is a slippery slope, though. You gotta be careful.
And about every one of our labor agreements says in any district
180.
stipulate numbers of days or more, and it varies by each group.
Yeah, so it's.
Yeah, we've never impacted that the way we've used it, which is.
Yeah, I don't want to start negotiating hours.
Oh, no, and that's
Right?
what I want to be. Okay,
That could get ugly.
very good. Thank you. Sorry.
Okay, we'll return to our previously scheduled program. Again, under section 800 operations, this one is the emergency preparedness and response policy. We now just use the acronym PEMA as opposed to Pennsylvania Emergency Management Agency. It refers to under delegation of responses to enforcement agencies. And once again, we changed police department to law enforcement agency. Under guidelines, it talks about emergency planning now is an actual title. And it says that the plan shall be accessible in each building. And once again, we took out police department and added law enforcement agency. On page 3, we've taken out local police and added law enforcement agencies. And then down into the next paragraph, it says appropriate activities qualifying as instructional days or hours for fulfilling the minimum required days or hours. Hours are added to everything there. And then it talks about how 1 hour of required, adding the word required training in the following areas shall be completed each year. And that's emergency training drills, fire drills, natural disaster identification or recognition of student behavior that may be a threat to the safety of students, other students, school employees, the facilities or other individuals. And that is the update for that particular one. Anything else on that?
And that's for the teachers. Teachers and staff.
Teacher, staff, the train, well,
Yeah.
fire drills. It's pretty much, if you're in, you're out,
Yeah.
the fire drills.
Mhm.
Okay, we're still under section 800. This is relations with law enforcement agencies. And here they've taken out the words under authority, local police departments, and have replaced it with law enforcement agencies with jurisdiction over school property of the school district. And that's in maintaining school safety and security. The next one says that the board directs the superintendent to have a memorandum of understanding, and here we've taken out each local police department and put in law enforcement agency that has jurisdiction. Under the definition, they've taken out, and this talks about incidents where it talks about tobacco products. Taking out the words vaping or juuling and putting in just global tobacco products. And conduct, it talks about under Schools Act, it says in school safety and security provisions of the school code. Then we have a lot under the memorandum of understanding, and it says in accordance with state law regulations, the superintendent shall form an advisory committee composed of relevant school staff to assist in the development of a memorandum of understanding with local law enforcement. Says that the superintendent shall execute and update every 2 years. And then taken out is police department and using law enforcement agency. And the understanding shall be signed by the superintendent, chief of school police, chief of police of the law enforcement agency with jurisdiction over the relevant school property. And then once again, substituting for Office of Safe Schools, the PA Department of Education. A whole host of things about the memorandum of understanding are taken out, and they've clarified that. And they've added in developing and updating the memorandum of understanding, the district shall consult or consider the State Board of Education model memorandum of understanding, and then model memorandum of understanding in accordance with applicable law and regulations. I think maybe that's a duplicate of wording.
Yeah, that pink section is being removed and we're adding the green section below it.
Right, but in the green section, it says State Board of Education, model memorandum of understanding, then there's a comma, and then model
Right, that should be,
memorandum
that's
of
a duplicate.
understanding is there again. That should probably come out
Yes,
just
that's
in
correct.
accordance, correct?
Correct.
Okay. Then we've added the memorandum of understanding shall comply with state law and regulations and set forth. And added are a procedure for law enforcement agency of the district's annual incident report required by law prior to the superintendent filing the report with the PA Department of Education. A procedure for the resolution of incident data discrepancies in the report prior to filing the report. And then number 3, additional matters pertaining to crime prevention agreed to between the superintendent and the law enforcement agency. So those are things added. We've changed again, police department to law enforcement agency several times throughout this. And then they've taken out Office of Safe Schools and put in PA Department of Education. And prior to submitting the incidents report, the superintendent and each law enforcement agency having jurisdiction shall do all of the following. And it talks about the submission within 30 days, and taken out is Office of Safe Schools and added is PA Department of Education. Police department came out, law enforcement agency is in, and then accurately reflecting police, it says law enforcement incident data. And we've changed Office of Safe Schools and Police Department again throughout as wording changes. Added is a paragraph that says, prior to submitting the report to the PA Department of Education, the superintendent and law enforcement agency shall attempt to resolve any discrepancy between the report and law enforcement incident data. If a discrepancy remains unresolved, the law enforcement agency shall notify the superintendent and the PA Department of Education in writing. And then the last item just changes police department and Office of Safe Schools again. Okay.
Just a question. So basically, under a memorandum of understanding, we as a district have to have 3 different memorandums of understanding. Then I would assume, is that what that's saying? You know, with each state police and Stroud Regional?
Yes, because the North Campus is covered by state police, Keith. So
Right, but that's Blooming Grove. Do we have to do two state police reports, or do we just do one and blanket it?
We have Swiftwater, which is now
Stroudsburg.
Stroudsburg,
Yep.
and then also Blooming Grove.
And then Blooming Grove. So it'd be 2 state police and 1 local authority, which would be Stroud. Yep.
Okay. Thank you.
All right. Shorter changes on school security personnel, still under 800 operations. On the second page, there is a portion where it talks about the school safety and security coordinator within 1 year of appointment, complete required trainings as specified by the state school safety and security committee for serving in the role of school safety and security coordinator. This training shall be in addition to other training requirements for school administrators, and added is, but shall count toward professional education credit where applicable. And then the next change talks about school police officers shall take and subscribe to the oath of office required by law within, this is added, within 30 days of court approval for appointment of a school police officer. The district shall notify the school safety committee and submit a copy of the court's order. And then added, in addition to that, it talks about doing everything in accordance with, and the word added is applicable law and board policy. And under requirements, added to the district shall annually report the following information. In the list of who gets that information is added the school safety and security committee. And that is the only number of changes in that policy. Anything else there? All right.
Who is our safety officer? Security, is that Chief Mill?
Chief Mill is the safety and security coordinator.
Okay.
All right. Under 800 operations, and the title of this one is child abuse. There are definitions now added. An adult is considered an individual 18 years of age or older. Bodily injury is defined as impairment of physical condition or substantial pain. A child is defined as an individual under 18 years of age. And under child abuse, there's the intentionally, knowingly, or recklessly doing any of the following. And these are all things that have been now spelled out and added. Causing bodily injury to a child through any recent act or failure to act, fabricating, feigning, or intentionally exaggerating or inducing a medical symptom or disease which results in a potentially harmful medical evaluation or treatment to the child through any recent act. But
Thank you.
causing or substantially contributing to serious mental injury to a child through any act or failure to act or series of such acts or failure to act, causing sexual abuse or exploitation of a child through any act or failure to act, creating a reasonable likelihood of bodily injury to a child through any recent act or failure to act, creating a likelihood of sexual abuse or exploitation of a child through any recent act or failure to act, causing serious physical neglect to a child, engaging in any of the following recent acts: kicking, biting, throwing, burning, stabbing, or cutting a child in a manner that endangers the child, unreasonably restraining or confining a child based on consideration of the method, location, or duration of the restraint or confinement, forcefully shaking a child under 1 year of age, forcefully slapping or otherwise striking a child under 1 year of age, interfering with the breathing of a child, causing a child to be present during the operation of methamphetamine laboratory, provided that the violation is being investigated by law enforcement, leaving a child unsupervised with an individual or other than the child's parent who the actor knows or reasonably should have known was required to register as a tier 2 or tier 3 sexual offender, has registered for life, or has been determined to be a sexually violent predator or sexually violent delinquent. Number 9 is causing the death of a child through failure to act. Number 10 is engaging a child in a severe form of trafficking in persons or sex trafficking, as those terms are defined by law. Then there is the term child abuse, does not include physical contact with a child that is involved in normal participation in physical education, athletic, extracurricular, recreational activities. Also excluded from the meaning of the term child abuse is the use of reasonable force by a person for the welfare of a child for purposes of supervision, control, or safety, provided the use of force. It says also constitutes incidental minor or reasonable physical contact in order to maintain order and control, is necessary disturbance or remove a child from a scene of a disturbance that threatens property damage or injury to persons, is necessary for self-defense or defense of another, is necessary to prevent the child from self-inflicting physical harm, or necessary to gain possession of weapons, controlled substances, or other dangerous objects that are on the person of the child or in the child's control. Okay. Any problem with any of those terrible things? All right. Serious mental injury is now considered, this is addition, all of this. A physiological condition is diagnosed by a physician or licensed psychologist, including the refusal or appropriate treatment that renders a child chronically or severely anxious, agitated, depressed, socially withdrawn, psychotic or in reasonable fear that the child's life or safety is threatened, or seriously interferes with the child's ability to accomplish age-appropriate development and social tasks. There is physical neglect is defined as any of the following when committed by a perpetrator that endangers a child's life or health, threatens a child's well-being, causes bodily injury, or impairs the child's health, development, or functioning. A repeated, prolonged, somebody say it for me. Egregious, exactly what I meant. Failure to supervise the child in a manner that is appropriate considering the child's development, age, and abilities. The failure to provide a child with adequate essentials for life, including food, shelter, and medical care. Sexual or abuse or exclude. Thank you. I'm reading too much. Is any of the following: the employment, use, persuasion, inducement, enticement, or coercion of a child to engage in or assist another individual in engaging or to engage in sexually explicit conduct, which includes but is not limited to the following: looking at sexual or other intimate parts of a child, another individual for the purpose of arousing or gratifying sexual desire in any individual, participating in sexually explicit conversation, either in person, by telephone, by computer, or by computer-aided device for the purpose of sexual stimulation or gratification of any individual, actual or simulated sexual activity or nudity for the purpose of sexual stimulation and gratification by any individual, actual or simulated sexual activity for the purpose of producing visual depiction, including photographing, videotaping, computer depicting, or filming. The conduct described above does not include consensual activities between a child who is 14 years or older and another person who is 14 years of age or older and whose age is within 4 years of the child's age. Any of the following offenses committed against a child: rape, statutory sexual assault, involuntary deviate sexual intercourse, sexual assault, institutional sexual assault, aggravated indecent assault, indecent exposure, incent, prostitution, sexual abuse, unlawful contact with a minor, or sexual exploitation. And a student is an individual enrolled in a district school under the age of 18 years. And then the next things that have changed are changed from she, he to the individual has committed child abuse. And then the final change for this one is changing, saying that the conduct being reported involves a school safety and security incident reported to be under law as opposed to the School Safety, Safe Schools Act, and that it shall inform the law enforcement agency that has jurisdiction over the property. And the last change is in investigation, where it says that the Department of Human Services of the Commonwealth and the word and or the county agency investigating can be notified. Anybody else want to talk about that one again?
I have one question on the page, the statement that defines a student as an individual enrolled under 18. How does that affect our students? We have some students that are over 18. How does this policy, how are they protected by this policy?
Well, if they're over 18,
They don't meet the definition
They don't.
by statute of being a child for this purpose. It doesn't mean that the actions wouldn't be subject to action under other district policies.
They're an adult, aren't they?
Well, they'd be considered, they're certainly an adult.
Yeah.
For sure, so,
They can be a student or
They can-
teacher can be an adult.
exactly.
We can still.
So that
Okay,
would,
so they
Who
still have protection under this policy then? I'm just making sure.
yep,
Okay,
we would immediately turn that then over. It wouldn't necessarily be the same. It wouldn't be a child abuse issue because they're not under 18, so they don't qualify there. So it would actually then turn into perhaps assault based on an adult. And then that would be
Okay.
turned over to law enforcement. Local authorities. Follow, Keith?
yep, I just want to make sure we're all protected. Thanks, Doc.
You got it.
Okay. We're in section 900 now. Community. This is public attendance at school events. The change in the definition here is for purposes of this policy. Tobacco product encompasses not only tobacco, but vaping products, including electronic cigarettes, tobacco products. And I think it might be a duplicate in the wording there again.
So didn't we just define that tobacco products before? And we just.
Well, now they have it in another section. It's like a.
Yeah, but
cross-reference,
you,
I
it's
can
two,
see.
you're giving two different definitions.
In these policies.
Definition of tobacco products be the same throughout all our policies.
Was it in your charge?
And
I
then
thought-
we addressed that on one of the other.
It talked about tobacco products, but that's where they took out juul and vaping and called it just tobacco products.
Yeah, so why do we have the vaping in this one?
Which one was that?
We took it out of the other, why
Under
would
a
you
student-
have it in it? I can't find, I'm trying to figure out where it is.
Back toward the beginning.
Do you remember which one it is?
I'm getting there.
I
Weapon. Student discipline, maybe? One before. Thought it was the first one.
Oh, yeah, it is under student discipline. So page 3
Which one, under this one?
says use or sale of alcohol or tobacco products. Or to conduct.
Right, and here it just expands upon not only tobacco, but also vaping products include. When they spell it,
Doc, is that considered an assumed,
I'm sorry?
is that considered an assumed idea that we define tobacco products? To be not only tobacco, but other vaping products. But we don't have to specify that in other policies, we can just identify it as tobacco products.
We do not.
Okay. So there you go.
Where?
That's fine then, as long as we've identified it here as tobacco products.
Hey,
They'll
tobacco.
cover
We can
your
do-
pattern.
So we don't have to put vaping on the last one.
no,
Yeah,
we do. We do because it helps to pinpoint in the list, it just says. It includes, but also includes vaping products, in other words, you can cross-reference it here.
We can say that, but we don't have to. Because in the other discipline.
Well,
we
you-
did use-
Well, no,
Took away-
discipline just says tobacco products, this defines tobacco products.
So this is a
So
full
it doesn't give us
definition.
And-
the defining tobacco products out of one. And we're adding tobacco with the definition of tobacco products into the other. Well, that's all I'm saying.
Well, the vaping is important because,
Oh, I'm just, but
yeah,
This
So why don't we
defines
leave it
it,
in
that just
discipline?
mentions it.
if vaping is important.
there's
why don't
another
we-
section on vaping. In discipline, I'm almost positive there's another section of vaping because we cover that through THC use.
Right.
Because we just had that discussion at the last meeting, the THC.
Yeah.
We want to extend that, we're going back to the old policy that we had with THC.
It's just a minor thing, so it's not, again, I'm not
I
gonna
got you.
change it, I'm just saying.
Yeah, then that definition needs to be
We
cleaned
take
up.
it out of one and we put it in the
Well,
other, that's all I'm saying.
Because they duplicate some of the things, so. All right, so, and there's just a little cleaning up there, Jen, right? All right, under tobacco and vaping products, we're not referring to specific names. and specific items. Which also carries through. Because there are so many items of that nature on the market. Under reporting, it's moved from Office for Safe Schools to annual school safety and security report. And then once again, we replaced police departments with law enforcement agencies. We've taken out names of specific product names. And that takes us through that one. All right, down to the last one for today. We're still in 900 community. This is municipal government relations. And this talks about is a policy of the board that the school district officials and municipal officials maintain a close and harmonious association. Such liaison is requisite for dealing with the school community concerns and issues and change from a satisfactory to an efficient manner, while assuring prudent expenditure of tax dollars, Changing police to law enforcement agencies again, twice in that particular one. Okay, we have no other old ones to go over since we had so many listed here. Public participation.
Yes. On open records. One of the requirements was to be a contact information for the state's office of open records. Currently, we don't have that on our website. And is there a specific appeal form?
They have model appeal forms with instructions, and we provide those instructions when we have the ability, or not the ability, but when we have the need, when a record is denied.
Reply to, right, no request.
Yeah, so what we do is when we have a request that is considered or deemed denied, there's language we have right from the OOR that we place into there, giving them all of the contact information and the instructions for appealing and the time frame.
The reason why the record, why that form is from the state and we don't develop is because local school districts could choose to develop that any way they want to. And then it changes the appeal process. So the appeal process comes from the state. The appeal process is not through the school district, it goes right to the state. The Office of Open Records. Did I get the initials right? OOR on that one? I didn't
OOR
want to confuse anybody.
or ORO,
Yep.
and word between
My
us
other-
OR.
Question on open records, Eric. What would be an example of the district? If a requested record is a public record, if the district has possession, custody, or control of that record, what would be an example?
An example would be minutes from a board meeting. It's a public record.
Okay,
Audited financial statements have
Financial
been approved
statements,
by the
right.
board.
Yeah.
so. The reason why I'm asking is because I dealt with, we weren't in possession of a record, so what would be an example? If we're not in possession of a record?
I'm going to turn it back to you and say, what did you request that I can give you an example of why we wouldn't have had it?
It would have been the filing of a labor relations complaint.
Well, without knowing the case, it could very well have been that that's not something we have to release under the law. There's certain things you don't have to release under the law. I mean, just because you make a request doesn't mean you get the document, right? What was the response you received back?
Possession.
There you go. That's the same thing as saying we can't release it or we don't have to release it. There's 100 ways that we can say we don't have to release a record. One could be we're not in possession. And in that case, maybe we weren't in possession of the document.
I can be even more clear and specific. I think I know the case you're speaking of. If we had a document and weren't releasing it, we would have to disclose the particular reason why we weren't. If we're not in possession of a document, it can be because the document that's being sought is one that's held and possessed by another agency. another Commonwealth
It's not part of
agency.
one of our files.
So it wouldn't be, we're not the repository of it.
Because in some cases, we may not be allowed to have a copy of it. It could be ongoing litigation. It could be 100 different reasons.
So then I should be exercising my appeal just to see how it plays.
And I guarantee you'll lose, especially if it's an active case or it's something that's of a nature that the public just can't have. There's many documents. The reason for the law is that there's some documents that the public should be able to get, and some districts, in many cases, weren't providing documentation, right? So they put this law in place. But there's also many documents that just get denied. You can't have it. It's that simple. You can't have every document. I don't mean you. I'm sorry. I don't mean to pick on you, but any document you request doesn't mean you're going to get it at all. There's many, many times that people are turned down, and you go through the request, you go through the appeal process, and guess what? I've never seen one turned over myself,
So,
because the law is clear on what we can release and what we can't release.
and what would be the difference if you're an elected school board director?
There wouldn't be a difference. Why would there be a difference? You might be privy to some information regarding a case in executive session, but you're certainly not any more or less able to make a request and get it. Nobody, it doesn't matter if you're a school board member. Doesn't matter. It doesn't change the law. The law is the law as to when documents and who they can be released to. What documents and who they can be released to. The law is the law.
So then, okay, then what I'm really hearing is that I need a better executive session.
But you still might not get information, because let me just explain. Just because it's executive session doesn't mean you're going to get an answer to every question you ask. You're simply not. Because if it's pending litigation, there's no way that, even if I know the answers to that question, even if our attorney's in the room and knows the answer, they're not going to share that information with anybody. It's just not going to happen. It's pending litigation. I mean, clearly and it's really for your protection and the school board's protection. Think about what exposure that would provide if suddenly something is discussed in executive session and somehow it's released. That's not a good situation to be in. So you're just not privy to certain information. You just can't, just because you're a school board member, and again, I'm not, it sounds like I'm picking on you, I'm not. But just because somebody is a school board member doesn't mean they get everything they want. It just doesn't happen that way. No way.
Well, as long as you're clarifying that with specific sections of school law, then I would have no problem with that.
It
Well,
might
listen,
even be school law, might be.
That my job is not, any superintendent's job is not to quote school law.
Well,
That's
you didn't have to, I did that today because you provide sections. of school law.
okay. Perfect. So then are we just gonna go around the circles and at the end of the day,
Wanted clarification,
but if you knew the answer, then why did we go through this exercise?
because I dealt with it personally.
But I understand that. I get that. But then why, if you knew the answers,
Well,
then why are we going through the exercise? It's not fair.
It sure is.
No, it's not. You're not being fair to me or anybody else on the
No, it has
dais.
nothing to do with it.
Well, but it does, because you made it that way, and that's not fair.
Well, that's not the intent,
Okay.
okay?
Any other questions?
Just real quick,
Sure.
I need a motion to authorize and direct administration to post the policy 218, 218.1, 218.2, 801, 803, 805, 805.1, 805.2, 806, 904, and 909, with noted revisions for public review during the month of August and subsequent board action in September.
So moved.
So moved, second.
Well, another country heard from. Okay, all in favor?
I'm in the state of Pennsylvania. I'm in the country. Sorry.
Are you in Pennsylvania?
Yeah, I'm in Erie right now.
Nice.
Okay, so we are now up to a motion for adjournment here at whatever time, 5:29.
Second.
Okay, thank you.